You have seen the documents?
Yes, Your Lordship.
So you pass an order?
Your Lordship, the documents do not relate to this.
You pass an order. You pass an order, consider the documents.
Please will pass.
Right? Pursuant to order dated 6th of December 2024, an affidavit has been filed by the petitioner. A supplementary affidavit has been filed by the petitioner dated 19/12/2024, annexing certain documents. He submits that whatever he has been placed on record. The learned counsel for the opposite party has submitted that an order can be passed considering the documents, but she submits that one or the other documents may not relate to the petitioner.
And also few documents are missing.
If it is missing, whatever it is, whatever they have filed it. Right? Considering the aforesaid submissions, अब कोई hearing की जरूरत नहीं है.
Yes, they will take decision on it.
The learned counsel for the petitioner has submitted that the opposite party be directed to take decision. The matter be adjourned so that the opposite party may take a decision and bring the decision on record. That's it. Considering the aforesaid submissions, the matter is adjourned and is directed to be posted on 14th of February. Right at that. Later. 21st February. 21st of February 2024. 2025. The supplementary show cause annexing the decision be filed by 20th February. You see, there are certain amendments in the supplementary affidavit. Take care of that. Whatever he wants to say with regard to one or the other document.
Item 45, CMP 612 of 2024.
Yes.
But for restoration of the WPS number 563 of 2023. This is for the court number 2024 because of non-compliance of my lord's order dated 35/2020.
Yes, CAP number 612 of 2024. This petition has been filed for restoration of WPS number 5632 of 2023, which stood dismissed on account of non-removal of defects in terms of order dated 13th of March 2024. The learned counsel for the petitioner submits that due to misunderstanding, the defects could not be removed within time. Considering the submissions, the time granted for removal of defect by the order dated 13th of May 2024 in WPS number 5632 of 2024 is extended till 30th of January 2025. If the defects are removed within the extended time, office is directed to place the writ petition before appropriate bench as promised. Preemptory ही है ध्यान दो. अब तक क्या हुआ? Reason order. मिल गया? क्या करना? I'll keep your वो कहाँ चले गए भाई हमारे पास भी तो रिकॉर्ड में आना चाहिए ना है आपके पास
कोई कॉपी नहीं है एफिडेविट नहीं है
कोई बात नहीं I'll just put it on record Contempt Civil 1094 of 2020 the learned counsel for the petitioner is present in the first half when the case was taken up it was submitted by the learned counsel for the opposite party that a reasoned order has been passed the counsel for the petitioner has submitted that a copy of the reasoned order has been given to him, but his claim has been rejected. Considering the aforesaid fact and the nature of the order passed by this court, this court finds that by passing of the reasoned order, the order has been complied. However, right is reserved with the petitioner to take appropriate steps in connection with the reasoned order as may be permissible under law. ऊपर लिखिएगा. Accordingly, this court is not inclined to proceed any further in this contempt proceedings, which is hereby dropped. The reasoned order produced by the petitioner is kept on record. आप ले लेंगे.
ठीक है
Item 46, Contempt Civil 647 of
इसको
2024.
बांध दीजिए उसमें. बांध दीजिए. टैग करिए उसको. हाँ बताइए.
Leadership has clearly said that there is no compliance on it. Because there were 3 prayers, I'll take leadership to the order directly, it's page 9. Paragraph 2 with the grievances of the petitioners. I'm only concerned with B. If I can read. For grant of 1 increment of pay in lieu of Bihar government servant, special provision related to family planning rules 1977, which has not been given to him in spite of recommendation by the concerned authority. I'll take my to the direction. That is paragraph 9. Next page. Accordingly, this petition is disposed of enabling the petitioner to approach the respondent number 2 by filing a representation raising her surviving grievances with regard to both the aforesaid points along with a copy of the report. The petitioner shall also produce adequate proof regarding the facts that the required steps were taken under the aforesaid rules of 1977.
When is the show cause reply?
Yes, Shoka's reply and the annexure 12, whereby they state compliance. So the first portion is my other place which is now complied with. Now the 2 the next is 30.
2 is what?
2 is this is the description with your permission if I can. 2 they write श्री रंजीत कुमार सिंह सेवानिवृत्त मापक विशेष भू अर्जन कार्यालय माध्यम संचय परियोजना चाईबासा द्वारा परिवार नियोजन भत्ता स्वीकृत करने के संबंध में उनके पत्नी लतिका सिंहदेव का निजी चिकित्सा से दिनांक 17/2/1996 को कराए गए नसबंदी के संबंधित प्रमाण पत्र सहित अभियावेदन उपलब्ध कराया गया.
तो वाइफ ने कराया.
हाँ,
वाइफ ने कराया. आपको तो कराना था ना.
इन्होंने भी कराया है 2 सर्टिफिकेट इन्होंने.
अच्छा, आगे बताइए.
बट द इशू इज दे से
आगे पढ़िए.
परिवार नियोजन भत्ता की स्वीकृति वित्त विभाग झारखंड ने परिपत्र संख्या दिनांक 3/10/2002 एवं स्वास्थ्य चिकित्सा शिक्षा एवं परिवार कल्याण विभाग झारखंड के पत्रांक दिनांक 29/7/2010 में निहित प्रावधानों के तहत दी जाती है. उक्त पत्रांक दिनांक 29/7/2010 में स्पष्ट उल्लेखित है अगर बांध्याकरण नसबंदी निजी अस्पतालों से रजिस्टर्ड चिकित्सक से कराया गया है उस प्रमाण पत्र को सिविल सर्जन अपर मुख्य चिकित्सा पदाधिकारी द्वारा सत्यापित किया जाता है तो उसे मान्यता दी जा सकती है. नाउ स्वास्थ्य चिकित्सा शिक्षा एवं परिवार कल्याण विभाग के प्राप्त परामर्श के आलोक में विभाग के पत्रांक दिनांक 25/2024 एवं पत्रांक दिनांक 12/6/2024 के द्वारा श्री रंजीत कुमार सिंहदेव को निजी चिकित्सक से कराए गए बंध्याकरण नसबंदी के संबंधित मूल प्रमाण पत्र वापस करते हुए स्वास्थ्य चिकित्सा शिक्षा एवं परिवार कल्याण विभाग के पत्रांक 155 दिनांक 29/8/2010 में वर्णित प्रावधान के आलोक में सिविल सर्जन अपर मुख्य चिकित्सा पदाधिकारी के स्तर से वांछित सत्यापन हेतु आवश्यक कार्रवाई कर उपलब्ध कराने के निर्देश विशेष भोजन पदाधिकारी मध्यम सिंचाई परियोजना चाईबासा के माध्यम से दिया गया. Means by they communicated me to get it verified. After my retirement, they want me to get it, and that is why in Ghar they have rejected my case, stating that it is not verified by you. So, let's see, if it is my case, then there was an appropriate direction. They could have gotten it verified. I had submitted my everything with them. Where does law doesn't warrant this? What is the impediment? They want me to get it verified. This is the only reason. Ghar में जो last 2 line है, if I
So
can
according to you, they should have got it
verified. Yes, simple. Because if I get it verified, then again they will doubt it, the genericity and the veracity of the document. So why don't they get it verified?
आप भेज दीजिए वेरिफिकेशन के लिए. You send it.
प्राइवेट हॉस्पिटल में ही कराए थे, इसीलिए इनको दिया गया कि आप इसको वेरीफाई करें।
रिकॉर्ड होगा, आप जाके वेरीफाई करें.
और वेरीफाई जो है गवर्नमेंट उससे ऑफिशियल से
ये सर्टिफिकेशन जो भी हुआ है प्राइवेट हॉस्पिटल में हुआ है, तो इसको सर्टिफिकेशन कौन कराएगा?
तो उनको करा के देना था, इस पर पॉलिसी तो यही है।
पॉलिसी कहाँ होता है कि इनको कराना था?
अगर आप प्राइवेट हॉस्पिटल में कुछ भी कराते हैं तो इसका वेरिफिकेशन जो है सिविल सर्जन से कौन कराएगा?
That is real. ये जो लिखते हैं रूल जो लिखते हैं what they have quoted that doesn't say that I should do it.
जब आपने प्राइवेट हॉस्पिटल से कुछ भी कराया है तो आप ही को ना वो डॉक्यूमेंट सिविल सर्जन के पास लेके वेरिफिकेशन करना था.
But the rule doesn't say about verification. The rule that we have in next 1977 rules, it is silent about verification. It says that you do it and we shall grant you one increment.
What is the date of your operation? 2002.
2000.
नहीं आपका ऑपरेशन
1996.
1996. आप एक बात बताइए, ये 1996 में जो करा लिया है, अब इसको 2010 का सर्कुलर से बोलिएगा सर्टिफिकेशन करा के लाइए.
जब हम कंसीडर कर रहे हैं तब जो प्राइवेट
अजय भैया, वो डॉक्टर भी मर गया होगा.
ठीक बात है, लेकिन जो पॉलिसी है
क्या पॉलिसी है? ये पॉलिसी कैसे एप्लीकेबल हुआ इनके ऊपर? अगर ये पॉलिसी पहले से होती ना तो वो करवा के रखते. अभी कहाँ से वो 2010 के वो 2096 में जिन्होंने ऑपरेशन किया, कहाँ से खोज के लेके आएंगे उनको? हाँ तो फिर
ऑब्जर्वेशन था 1977 रूल्स के हिसाब से देंगे.
लिखिए कंटेम्प्ट सिविल 647 of 2024. Counsel for the petitioner submits that the claim for
Ground, that is prayer 2B, page 9.
The claim for grant of one increment of pay in view of Bihar government servant within bracket special provision related to family planning bracket close rules 1977, which was duly recommended by the concerned authority, has been denied and appropriate direction was passed by this court to consider the same, has been denied by the respondents by passing an order dated 25/7/2024 by referring to a departmental circular dated 29/7/2010. He submits that the required steps was taken by the petitioner in the year 1996.
1996.
And the opposite party are asking the petitioner to get it verified from the concerned civil surgeon by virtue of the letter dated 29/7/2010, by virtue of the circular dated 29/7/2010, which never existed way back in the year 1996. Had it been there, then the petitioner would have taken appropriate steps at that relevant point of time. The fact remains that there was due recommendation for grant of benefit to the petitioner. At this, the counsel for the opposite party is unable to satisfy this court as to how the order passed by this court has been complied in letter and spirit. And बताइए, फ्रेश शो कॉस्ट फाइल
इसको रेस्ट पार्ट हो गया, एक ये पार्ट बचा है, इसको
कर दीजिए. अननेसेसरी परेशान करते हैं आप लोगों को, मिलते नहीं आप ठीक से.
नहीं इसमें आप क्या मिलेंगे?
ऐसा मिलने का कुछ नहीं, कसम दिया. पेमेंट रिपोर्ट भी हम मंगा लिए
I
हैं.
have proven my bona fides in 1996 अभी.
पेमेंट रिपोर्ट भी हम मंगा लिए हैं. इनको एमएसपी का डिफरेंस अमाउंट
इसको ये गलत है, बिल्कुल ही गलत.
इसमें दो पार्ट हैं, थोड़ा सा
एकदम गलत. ठीक है ना? दिस इज नॉट प्रॉपर. और इनफैक्ट अगर कोई देखिए किसी को कुछ गड़बड़ करना होता है ना तो ये जाके सर्टिफिकेशन करा के ले आते
नहीं 77 वाला जो है प्रोविजन
गलत
उसके
है
हिसाब
ना?
से देख लेते हैं।
हाँ देख लीजिए उसमें अगर सर्टिफिकेशन की बात है then we don't have
आप
any.
देख लेते हैं।
The counsel for the opposite party prays for time to file supplementary show cause. Let the supplementary show cause be filed by 28th February. काफी by 27th February. Post on 28th. In supplementary cause list. कहाँ से आप लोग सर्कुलर बनाते हैं कि कुछ कहने का नहीं.
Item 47, Contempt Civil 651 of 2024.
Complied? What have you stated in your show cause? कर दिया जाएगा तो पेमेंट क्यों नहीं?
Payment भी कर दी है लॉजिक।
कहाँ है?
Payment is not come on record. You made the payment also.
You have done the payment. Should I record it?
Yes, lordship, the monthly payment is being made monthly, but the whatever areas were there, you should pay.
What was the order? Was there any direction to make payment?
Yes, your lordship, the payment will be made within 1 month, within we made it, your lordship. The show cause only has annexure which says the compensation amount.
देखिए Contempt Civil 651 of 2024. The learned counsel for the nobody appears for the petitioner. The learned counsel for the opposite party has submitted that, as per the show cause dated 28/10/2024, the petitioner is held entitled for payment. She has submitted that, as per her instructions, admissible amount has already been paid. But this fact has not been mentioned in the supplementary show cause. Correct? No, on 29/10 there is already an order. You have not complied that.
The payment, your lordship, I have to bring on record the payment that has been made.
Let the supplementary show cause be filed by the opposite party number 2 by 29th of January.
Yes, your lordship.
Post on 31st of January in the supplementary cause list.
Item 48, Contempt Civil 688 of 2024.
Yes.
They have passed a decent order that is annexed with their show cause reply. That order is dated 9.
You are aggrieved?
Because I am aggrieved by this order, but
Contempt Civil 688 of 2024. Counsel for the parties are present. A reasoned order has been passed pursuant to order dated 28/6/2023, passed in WPS number 456 of 2021. The counsel for the petitioner has submitted that the petitioner is not satisfied with the reasoned order. Counsel for the opposite party has submitted that the order of this court has been complied. Considering the aforesaid submissions, the order of the court having been complied though belatedly, this court is not inclined to proceed any further in this contempt petition. Accordingly, the contempt proceedings are hereby dropped. However, liberty is reserved to the petitioner to take steps in connection with the reasoned order as may be permissible under law.
Item 50. Item 50, Contempt Civil 880 of 2024.
Serial 47, I could not appeal. The order has been complied.
Order has been complied. Serial number?
47.
47, your lordship, the payment that has been made.
Serial number 47 में फिर से you have taken the dictation 47 का कौन लिया? आप फिर से ले लीजिए. विनीत जी आप हैं यहाँ पर? छोटा सा ले लीजिए. Counsel for the parties are present. Counsel for the petitioner submits that order passed by this court has been complied though belatedly. Considering the submissions, this court is not inclined to proceed any further in the contempt proceedings. Accordingly, the contempt proceedings are hereby dropped. Appearance memo दे दीजिए please.
Item 50.
This order dated 6/21/24, this was not been complied with.
We have filed IA for recall.
Which order?
6/12/2024.
क्या order?
Kindly to paragraph 6 of order.
Paragraph 6. Yes.
We have been directed to deposit an amount of ₹5,0967. Reasons were recorded that the state is not pursuing the LPL.
Yes.
Now the limitation had not been filed, but for recording the order. But my lord, we have stated in IA, my lord, the limitation was filed prior to the passing of this order. It could not be pointed out. Or 21.
But at the time of passing of this order, they have not removed the defects.
ये reason नहीं है ना? क्या ही कर रहे हैं आप लोग? LPA में defect remove हो गया?
जी हो गया, नंबर भी पड़ गया।
नंबर बताइए।
नंबर है इसका 633 और 24।
वो रजिस्टर्ड हुआ है
आइए नंबर बताइए। आपने कब फाइल किया लिमिटेशन पिटीशन?
लिमिटेशन फाइल हुआ है मतलब 21 नवंबर 24।
कहाँ से पता चलेगा?
ये स्टेटस भी लगा है मतलब
Status.
annexure A to the IA my lord, page number 20, page 19 is 11 my lord,
पेज नंबर
19 is the IA my lord,
19 of the IA.
one is for stay and one is for my lord limitation. IA details में आ रहा है।
261 पेज नंबर 19। कहाँ लिखना है आपका लिमिटेशन फाइल में?
लिमिटेशन मतलब स्टेटस में आ रहा है यहाँ पे 21 नवंबर 2024, नीचे में कॉलम में IA डिटेल्स में
21 of November IA detail 12431 ये नंबर है?
यस, एक स्टे का है और एक लिमिटेशन का है।
ऑर्डर कब हुआ था यहाँ से?
6/12
उससे पहले दो स्टेटस हम भी लगाए हैं और रिकॉर्ड पे भी लिया गया था। उसमें ये आईए रिफ्लेक्ट नहीं कर रहा था, तो हम रिप्लाई जो किए आईए का उसमें लगाया हुआ है।
कब डाउनलोड किए हैं, कब क्या किया?
हाँ, हम टाइम के साथ डाउनलोड किए हैं। उसमें टाइमिंग है, डेट भी लिखे है उसमें।
इसको जरा देखिए तो ये कौन सा आई है आपका?
इस जो कंटेंट में
इन दोनों में से कौन सा आई है आपका लिमिटेशन?
दोनों में सेम ही डिफाइन हुआ है।
नहीं, कौन सा आई है आपका लिमिटेशन का है?
एक बार ये हम वेरीफाई करवाना है।
अच्छा,
reading
ये
भी-
जरा इसका स्टेटस वेरीफाई करिए तो 12430 of 24
LPA में पेंडिंग है।
हाँ। कब फाइल हुआ?
21/11/24।
फाइल
हुआ है, हम कहाँ उसे डिनाई नहीं कर रहे हैं, लेकिन ये एट दैट टाइम व्हेन द ऑर्डर वाज पास्ड बाय दिस ऑनरेबल कोर्ट, एट दैट वेरी टाइम entire defect has not been removed, that's why this IA has not been reflected on that date.
बताइए आपका कहाँ आप फाइल लगाए थे?
जी, हम लगाए रिजवाइंडर फाइल किए हैं।
रिजॉइंडर कब फाइल
इसका
किए थे?
रिप्लाई ये
एक
हम
सेकंड,
फाइल
इसको हम लोग थोड़ा सा रिजॉल्व करते
हाँ, इसको रिजॉल्व करना होगा।
करते हैं। बताइए किसी
इसका
का रिजॉइंडर में?
हम रिप्लाई फाइल किया आईए का एनेक्चर R/1 हम लगाए हैं उसमें हम डिटेल लिखे हुए हैं कि हम किस किस दिन हम निकाले हैं स्टेटस। पैराग्राफ 3 को देखा जाए।
आप हमको बताइए ना।
जी, यहाँ पे एनेक्चर पेज नंबर 11 में देखा जाए।
पेज नंबर 11
जी, उसके लेफ्ट कॉर्नर में लिखा 27/11/2024 का एक निकाले 7:42 में एक स्टेटस, उसमें आईए नंबर नहीं दिया हुआ हुजूर। दूसरा स्टेटस हम निकाले हैं 29/11/2024 को 10:36 में उस दिन केस फिक्स था, उस दिन निकाले हैं। नेक्स्ट ये स्टेटस निकाले हैं हुजूर 6/12/2024 को, जिस दिन ये ऑर्डर हुआ उस दिन भी स्टेटस रिफ्लेक्ट नहीं कर रहा है कि आईए फाइल किए हैं, और इसी स्टेटस को देख के ऑर्डर हैज बीन पास्ड ऑन 6/12/2024। Thereafter, this registration of the LPA has been this LPA has registered on 16/12/2024 after passing of this order। जब पूरा डिफेक्ट रिमूव हो गया देर और वो 16/12/24 को रजिस्टर्ड हुआ, उस समय तक आईए का स्टेटस रिफ्लेक्ट नहीं कर रहा था।
कोई बात नहीं, इसको जो है ना जरा किसी कंप्यूटर सेक्शन वाले को जहाँ है उनको बुलाइए, इसको समझना बहुत जरूरी है क्योंकि स्टेटस पे हमें बहुत
फाइलिंग नंबर से हुआ होगा।
उसके लिए
उस पीरियड में क्या होता है, बहुत चीज इफेक्ट नहीं करता।
एक हम
जब इसका रजिस्ट्रेशन हमने पढ़ा ना, उसके बाद से फिर ये सारा चीज
अच्छा फाइलिंग नंबर से हुआ।
हाँ, जब रजिस्ट्रेशन नंबर हो गया तो जो अर्लियर फाइलिंग हुआ होगा आइए वो भी फिर इफेक्ट करने लगता है।
अच्छा
मतलब एक दूसरा एलपीए का भी हम निकाले हुए हैं स्टेटस जिसमें डिफेक्ट नहीं, उसमें भी आईए रिफ्लेक्ट नहीं कर रहा है।
नहीं इसलिए नहीं कर रहा है। सुनिए, देखिए हमारे कोर्ट मास्टर साहब कंप्यूटर में एक्सपर्ट हैं, जिनसे हम बहुत असिस्टेंस लेते हैं। इनका ये कहना है जब फाइलिंग नंबर से कोई चीज़ पड़ता है
जी
तो तुरंत वो रजिस्टर नहीं होता,
नहीं होता बिल्कुल
ठीक है, इट टेक्स इट्स ओन टाइम, और ख़ास तौर पे अगर पिटीशन डिफेक्टिव है
जी, वही हम भी लिखे हैं।
तो इस सर्कमस्टांसेस में इन्होंने फाइल कर दिया होगा। जब इनका आईए नंबर पड़ा होगा तो वो डेट ऑफ फाइलिंग नंबर के डेट से
कैच
Pick up
कर
that.
हाँ जी, वो हम लिखे हुए, अपना रिप्लाई भी लिखे हुए हैं और ये भी लिखे हुए
अब
मेयरली
एलपीए फाइल हो गया है
जी,
इस
उसका
order
उसका
का
भी रिप्लाई है, उसका रिप्लाई एनेक्सेड ये देखा जाए, वो इम्पोर्टेंट चीज़ है। अब इसलिए जब ये ला रहे हैं ऑर्डर को नहीं कंप्लाई कर रहे हैं, उसके लिए आप ये R2 देखा जाए।
देखिए इतना बहस जो है ना कंटेंट में
जो
नहीं होता
बहस
है।
नहीं कर रहे, हम
LPR
असिस्ट कर, मालूम हम सिर्फ असिस्ट करना
नहीं
चाहते
नहीं,
हैं कि
देखिए हमारा जो ऑर्डर है ना उसमें क्लियर है कि इन्होंने लिमिटेशन पिटीशन भी नहीं फाइल किया है, टाइम बाद अपील है, इसीलिए ये ऑर्डर हुआ है। अगर लिमिटेशन वगैरह फाइल कर लिया होता ना तो हम इस
वो
तरह
हमारे लिए उसके लिए हम कोई कभी
तो अभी तो
जब
फिलहाल
हम
वही
दूसरा
कर रहे हैं।
दूसरा लाइन ऑफ आर्गुमेंट कर रहे हो
फिलहाल तो इसको ऑर्डर को रिकॉल करें क्योंकि दिस ऑर्डर इज रिफ्लेक्टिंग इट हैज बीन पास्ड बिकॉज द लिमिटेशन पिटीशन वाज आल्सो नॉट फाइल्ड।
पर ऑन दैट वेरी डेट जब जो रिफ्लेक्ट नहीं कर रहा था, जो हुजूर का जो ऑर्डर है उसमें लिखा हुआ है कि हम रिकॉर्ड पे लिए हैं वो स्टेटस को, उस स्टेटस में नहीं रिफ्लेक्ट कर रहा
आपको
था।
बताना पड़ेगा ना कि नाउ दे हैव एंड दिस इज द एक्सप्लेनेशन फर्निश्ड बाय द लर्नेड कोर्ट मास्टर, ही इज अवेयर अबाउट द कंप्यूटर सिस्टम।
और मेयरली फाइलिंग ऑफ द अपील उसीलिए हम
आपकी बात बिल्कुल सही है, मेयर फाइलिंग ऑफ द अपील, लेकिन ऐसे भी ऑर्डर्स हैं। देखिए
मतलब
हम
सुप्रीम कोर्ट ऑनरेबल अपेक्स कोर्ट
आप
ऑर्डर
अपेयर हो
है,
गए ये में
हम आप कैसे अपेयर, हम तो नहीं किए हुए हैं, उसमें
क्या किए हैं,
कैविएट फाइल किए हुए हैं।
केवेट फाइल किए हुए
जी,
तो
जी,
कोर्ट में
बिल्कुल।
मेंशन करिए,
डिफेक्ट तो अभी 6/12 को
मेंशन करिए ना
16
कोर्ट में
बार
जॉइंटली।
remove
आप
किए।
तैयार है ना
जी,
एक्सप्लेनेशन, जॉइंटली मेंशन कर दीजिए, वी जॉइंटली मेंशन।
वो तो हम करेंगे, लेकिन एक हम ऑर्डर खाली हम दिखाने से प्लीज काइंडली एक मेरा ऑर्डर देख लिया जाए।
देखिए इतना हेस्ट में नहीं चल सकते
मतलब
हैं
हेस्ट
ना।
नहीं कर रहे, हम सिर्फ असिस्ट कर रहे हैं। सिर्फ असिस्टेंस तो हमारा अधिकार है ना, हमको असिस्ट तो कर सकते हैं। उसमें बोला जाता है एक ऑर्डर आप देखा जाए, पेज नंबर 18 को देखा जाए, मेरा रिप्लाई।
देखिए इतना अभी इस तरह का
मतलब सिर्फ हम असिस्ट करें। अगर दे डोंट वांट टू इवन आफ्टर रिटायरमेंट दे आर डूइंग 139 दिन का डिले के बाद फाइल कर रहे हैं अपील, उसके बाद डिले कर रहे हैं। देखा जाए पेज नंबर 18 का लास्ट पैराग्राफ पढ़ते हैं। हर लर्नेड काउंसिल फॉर द पार्टीज इन आवर व्यू इन द फैक्ट्स एंड
देखिए ये सब है ना इस तरह के ऑर्डर्स, कॉन्ट्राडिक्टरी ऑर्डर्स भी है ना।
हम लोग तो रिसर्च करके यही मिला जो हम
नहीं,
लोग
इसका कॉन्ट्राडिक्टरी ऑर्डर्स भी मेरे पास आया हुआ है। देखिए कोई भी केस में जब सुप्रीम कोर्ट ऑर्डर करता है तो इन द फैक्ट्स ऑफ अ केस करता है, ठीक है। तो इसीलिए ये 141 का बाइंडिंग प्रेसिडेंट नहीं है, when it depends upon very many facts of a case, right?
मतलब इसमें तो ये बोला कि merely filing of the IA petition।
आपकी बात सही है, merely filing of the IA petition। यहाँ पर एग्जीक्यूशन का स्टेट का पिटीशन फाइल करने के बाद सिविल कोर्ट में कितना डेट लेते हैं ना,
हम लोग
कि नहीं लेते हैं।
क्लाइंट के लिए तो बहस करेंगे ना।
अच्छा ठीक है, उनको बता दीजिएगा कि हम बहुत बहस किए हैं, ठीक है। आपका ये सब लिखा देते हैं।
जी जी,
आप आइए बताइए।
आइए नंबर मतलब 265 और 2025।
इसमें क्या है?
In paragraph 12, they have stated that the IA for limitation for following delay was filed on 21st of November 2024.
ये आइए नंबर ही नहीं मिल रहा आपको।
सारे केस में ऑर्डर होता है, पहले डिफेक्टिव रीड फाइल एलपीए फाइल करते हैं, फिर उस कंटेम्प्ट में कुछ ऑर्डर होता है उसको आईए बना के फिर रिकॉल करवाते हैं। दिस इज द प्रैक्टिस। ये प्रैक्टिस
आपका केस बहुत कॉम्प्लिकेटेड होता है। तो आपका
Complicated नहीं
कंटेंट
है,
कितना कॉम्प्लिकेटेड है तो आपका केस कितना कॉम्प्लिकेटेड है। चलिए, दिस इज फॉर रिकॉल।
Yes, ma'am.
और भी कोई है?
नहीं, बस यही है।
IA number 261 of 2025 in Contempt Civil 880 of 2024. The learned counsel for the petition opposite party has submitted that this interlocutory application has been filed for recall of order dated 16/12/2024. Six 6/12/2024, wherein this court has directed the opposite party to deposit the entire amount in the bank account of learned Registrar General on the ground that although the LPA was filed, but the same was barred by limitation and even the petition for condonation of delay was not filed in the LPA. The learned counsel has submitted that on the day the order was passed, the petition for condonation of delay was filed, and in support of that, he has annexed the status report showing the filing of the interlocutory application on 21/11/2024. He submits that he had no intimation regarding the aforesaid fact, and therefore this fact was not brought to the knowledge of this court while passing order dated 6/12/2024. He has submitted that now all the defects have been removed in the LPA, which has been numbered as 633 of 2024, and the state shall take all steps for expeditious hearing of the LPA. To this, the learned counsel for the petitioner has submitted that as per the status report which was filed by the petitioner on the day when the case was taken up, the filing of the interlocutory application was not shown. And therefore, such a submission was made on the basis of status report. He has also submitted that he has entered caveat in the case, in the LPA. The learned counsel has further submitted that mere filing of LPA or interlocutory application in the LPA cannot be a ground for non-compliance of the orders passed by this court. And therefore, the order dated 6/12/2024 may not be recalled. Upon a query by this court to the learned courtmaster, it has been informed that certain interlocutory applications are filed and filing number is provided, but the number of interlocutory application is provided later, and once the number is inserted in the computer system, IA number is shown with the date of filing of the interlocutory application, which could be a reason for the aforesaid mismatch. Considering the arguments of the learned counsel for the parties, and it appears that on 6/12/2024, the correct fact regarding filing of the limitation petition was not brought to the notice of this court, and it appears that the limitation petition was filed in the LPA.
And ये इस पैराग्राफ में वो जो इसके जगह पे जो हम डाले थे
Please,
वो करा दिए.
just a moment. Accordingly, the order directing the opposite party to deposit the amount in the bank account of Registrar General is hereby recalled. This court is of the view that this court is of the view that although filing of LPA by itself or stay petition in LPA may not be a ground for non-compliance of the orders passed by this court, but at the same time, this court would show restraint once the LPA has been instituted and the petitioner has already entered caveat. The opposite party has already undertaken to take steps for expeditious disposal of the
टाइम फ्रेम करते हैं.
टाइम फ्रेम नहीं करेंगे,
उसमें
नेक्स्ट डे रखेंगे.
एक चीज और मेरे अगेंस्ट में चला रहा है वो इनकम्प्लीट वो जो इन्फॉर्मेशन है रॉन्ग इन्फॉर्मेशन वाला पार्ट वो ड्यू टू द स्टेटस रिफ्लेक्ट ऑन दैट वेरी डेट वो लिखवा देते. ठीक है, तो
तो वही तो लिखे ही हैं. अभी देखिए ना क्या करते हैं. पोज दिस केस ऑन 6th of March 25. It is further observed that the reflection of filing of LPA in the computer system. It is further observed that the informations which are available in the computer system are used during various proceedings, and therefore this court is of the view that it is important that the filing of interlocutory application or any
caveat which reflect
or any matter in connection with one or the other case should reflect at the earliest. This matter be placed before the computer committee of the High Court for doing the needful. ठीक है? Resolve कर देंगे ना इसको.
caveat फाइल करें उसमें भी नहीं रिफ्लेक्ट कर रहा है कि कोई
ये हो जाएगा. आप लोग ये सब रिप्रेजेंटेशन तो देते नहीं है, कभी दिए हैं?
हम लोग तो देते हैं अपना एसोसिएशन में देते हैं.
एसोसिएशन में नहीं भाई, आपको एसोसिएशन को बोलिए. आप अगर एक आदमी भी दे देगा तो काफी है ना, क्योंकि इट इज समथिंग वेरी सीरियस. एक केस में सिविल कोर्ट का स्टेटस लेके गलत ऑर्डर हो गया कि केस क्लोज हो. ठीक है, तो इस तरह से तो दिक्कत है. दीज सिस्टम्स आर वेरी इंपॉर्टेंट. इसको कोई भी यूज करेगा, सुप्रीम कोर्ट में यूज करेगा, कहीं भी यूज करेगा, कोई
हर चीज दिखना चाहिए जो आप फाइल कर रहे हैं सारा चीज.
तो ये कंप्यूटर कमिटी ही इसको रिजॉल्व करती है, हम लोग नहीं करते. अगर आपको केविएट में भी यही प्रॉब्लम है तो आप लिख के दे दीजिए,
क्योंकि हमने स्टेटस जो लगा हुआ उसमें केविएट नंबर 193 2024 फाइल जो की है इस केस में उसमें भी रिफ्लेक्ट नहीं कर रहा है. होना चाहिए ना कि हम नहीं अब तो हम जाके वहाँ बोले कि इसको रिफ्लेक्ट करवाइए क्योंकि केविएट नहीं है.
तो बाकी सारी चीजें भी हो जाएगा रिजॉल्व. ऐसा कुछ बड़ा चीज नहीं, बस खाली नजर में आने भर की देर है. अब मेंशन करके कर लीजिए
जी. उसमें खाली लिखा देते स्टे लेके आते उस डेट के पहले तो थोड़ा सा एक्टिव रहते हो, जो अदरवाइज रिटायर्ड पर्सन है, इसीलिए हम लोग थोड़ा वर्डिड रहते हैं.
Item 51 CMP 886 of 2024.
Restoration of WPS number 685. The order the 18/6/24. The petitioner was given time for removing the defect. But
आपका रीट का नंबर क्या था?
The रीट का नंबर था 6850
of
2020.
Common.
क्यों नहीं रिमूव कर पाए?
8624 could you be remove my lord, I have stated the reason my lord
क्या लिखे हैं? रीजन बताइए.
that was my type copy was only to be given, that was my lord given to the my lord who could not come to the court, and I was under suggestion that it had been filed my lord on 21/6 after 2 days. All the defects have now been removed. दो दिन का उसमें ले
CMP number 886 of 2024. Counsel for the parties are present. This petition has been filed for restoration of WPS number 6850 of 2023, which stood dismissed on account of non-compliance of order dated 17/5/2024 due to non-removal of defects within the stipulated time. The learned counsel for the petitioner submits that due to non-availability of the advocate's clerk, the defects could not be removed within time. Counsel for the opposite party has no serious objection to the prayer for restoration. Considering the submissions, the time for removal of defect given in the writ petition WPS number 6850 of 23 by the order dated 17/5/2024 is extended till 31st of January 2025. If the defects in the writ petition are removed within the extended time, office is directed to place the writ petition before appropriate bench as per roster. This CMP is accordingly disposed of.
Item 52, Contempt Civil 1026 of 2024.
It should records have to be got from other authorities as well. Your Ladyship, earlier I had taken time, but I'm seeking 2 weeks more time. Your Ladyship, that fact is recorded in the order sheet itself.
6/12/2024, he has taken 4 weeks time. It was granted by this.
You have to file compliance report.
Yes. The documents have to be got from other authorities, Your Ladyship. It is recorded in the order sheet also. That is where it's taken. The order passed by the writ court. Page
By
number
the
20.
writ court.
Yes. Page number 20.
आपके जो अदर अथॉरिटी कहाँ रहते हैं?
That is only 2 weeks more time.
कहाँ रहते हैं?
डिस्ट्रिक्ट एस्टेब्लिशमेंट दूर का है।
हम सोचे चांद वाले
डिस्ट्रिक्ट कमिश्नर कोई डायरेक्शन
मून में नहीं रहते ना। यहाँ से मून में जाने में के लिए कितना टाइम लगता है? नहीं है? शुड नो। उससे कम ही टाइम लगेगा तुमको जाने के लिए।
By way of last one, it will be
कौन अपीयर होंगे अगर ऑर्डर कंप्लाई नहीं होगा? आपको 4 हफ्ता देंगे। लेकिन आप बताइए कौन है?
Director Panchayat.
What was the nature of order?
MSCP
MECP benefits have to be extended. Your Ladyship, we have to consider
And
its
to revise
representation
them.
and pass a recent order.
सिमिलर है ऑलरेडी बीन एक्सटेंडेड।
एक गलती इस तरह के ऑर्डर्स में क्या हो रहा है कि इंटरेस्ट पेमेंट का ऑर्डर नहीं हो रहा है डिफॉल्ट पर, वो होने से हो जाता है। आगे से ध्यान रखें। Whenever there is a direction for entitlement of any payment, an amount is to be released. If the amount is not released within time, 10% interest from the date he became entitled till the date of payment. जितना का अमाउंट नहीं होगा उससे ज़्यादा इंटरेस्ट पेमेंट करना पड़ता है। वही सब ऑर्डर ठीक रहता है आपको।
Your Ladyship, only 14 days.
I'll give you time. Compliance report चाहिए, amount remit करके। ठीक है?
But his entitlement has to be seen.
Yes, yes. Provided he is entitled.
Yes.
Right? If he is entitled, you file a compliance report. I'll give you 4 weeks time. Contempt Civil 1026 of 2024. The learned counsel for the parties are present. The learned counsel for the opposite party has submitted that the entitlement of the petitioner has not been decided in view of the fact that certain documents are required to be called for from the other authorities, as is reflecting from the order passed in WPS number 6628 of 2023. He prays for 2 weeks' time to file a compliance report. However, this court is inclined to grant 4 weeks' time to the opposite party to file a compliance report in this case and annex the copy of the reasoned order, and after remitting the admissible amount to the petitioner, if he is found entitled to any financial benefit arising out of reasoned order, the show cause should reflect that the amount has been remitted. Was this case on Batai?
Any day after 4
1, 2, 3. Was this case on 14th of February 25? The compliance report be filed by 13th.
Item 58, Contempt Civil 27 of 2025.
Where is the order? हाँ बताइए,
क्या इसमें चाहिए इसमें शो कोस फाइल करना है
शो कॉज की कंप्लायंस
कंप्लायंस
एलपीए तो नहीं फाइल किए हैं, तो कंप्लायंस रिपोर्ट ही फाइल करेंगे. Contempt Civil 27 of 2023. Counsel for the parties are present. Counsel for the opposite party prays for 2 weeks' time to file compliance report. Pose this case on 7th of February in the supplementary cause list. The compliance report should be filed by 5th of February.
Item 59, Contempt Civil 30 of 2025.
Yes.
I'm also praying for 2 weeks time of filing compliance. Looking for the first.
Same order कर देते हैं.
Item 60, Contempt Civil 33 of 2025.
Yes, petition.
Please, Your Worship. This contempt may arise from the order dated 14/5/2024.
Where is the opposite party?
Which is the annexure 1 of page 13 of WPS of 46274 of 2023, and that writ petition has been filed for the relief to grant the promotion and financial benefits of ACP to the petitioners. I'd like to draw the attention on point number 7, my lords, page number 14.
The direction was upon respondent number 2. Who was respondent number 2? Director.
Director, ring pass.
भाई compliance report फाइल करिए. Same order कर लीजिए.
Much obliged.
Item 61, Contempt Civil 46 of 2025.
OP number 2. Function was to the regional director.
You are not representing OP number 3.
No,
Regional Director.
Yes.
I am appearing on behalf of OP number 1. Department List.
झारखंड इंडस्ट्रियल एरिया डेवलपमेंट. मिस्टर बॉबी को जानते हैं?
और वो रिसीव नहीं किए कि कंटेंट में वो रिसीव नहीं करते.
अच्छा तो मैंने पुलिस स्टेशन से भेज देता हूँ.
दे सकते हैं.
देखिए कंटेम्प्ट सिविल 46 of 2025. Counsel for the petitioner is present. He submits that order passed by this court in WPS number 6758 of 23 dated 21 February 2024 has not been complied with. Counsel for the state is present. Let notice be issued to the opposite party number 2 through the concerned police station so that the for which recusals be filed by the petitioner before this court by Tuesday. Counsel for the state is directed to seek instructions from the officer in charge of the concerned police station and file affidavit regarding service of notice. ठीक है? कहाँ का पुलिस स्टेशन है? रांची का ही है तो बहुत बढ़िया बात है. आप का फाइल कर दीजिए. ठीक है? Post this case on 7th of February in the supplementary cause list, awaiting compliance report. Show cause as to why contempt proceedings be not initiated against OP number 2 for willful and deliberate non-compliance of order passed by this court.
Item 62, Contempt Civil 75 of 2025.
Not compliant.
First time we will file so cause also.
शो कॉज की कंप्लाइंस एलपीए फाइल किए हैं? नहीं किए ना, तो कंप्लायंस रिपोर्ट फाइल होगा, शो कॉज नहीं. ठीक है? कौन किसको डायरेक्शन था?
Respondent number 4.
फ्रेमिंग ऑफ रूल्स. क्या बात है भाई? What is it?
Community health assistant.
और रिस्पॉन्डेंट नंबर 2 को डायरेक्शन था 4. और यहाँ पे कौन है 4? एडिशनल चीफ सेक्रेटरी. Learned counsel for the parties are present. Learned counsel for the state prays for and is granted time till 21st February to file a compliance report. क्योंकि ये रूल लाना है ना, यहाँ पे मत टाइम मांगिएगा फर्दर. रिट पिटिशन में एक्सटेंशन ऑफ टाइम के लिए प्रेयर करिए. कंटेंट में एक्सटेंशन ऑफ टाइम नहीं होता.
6 weeks दे दिया.
6 weeks हो गया. आपके बिना मांगे हम दे दिए. ठीक है? Post this case on 7th of March in the supplementary cause list. रूल नहीं बनाते आप लोग, उसके लिए कोर्ट का ऑर्डर चाहिए. स्टेटस को चाहिए सब, नहीं न रूल बनेगा न किसी को कोई रिलीफ मिलेगा, और बस स्टेटस को चलते रहे. दिस इज द पॉलिसी ऑफ द स्टेट. इधर यू से दैट नहीं बनाना, यू टेक अ डिसीजन, स्क्रैप कर दीजिए एक्ट वैक्ट सबको मतलब क्या बोलें, खत्म कर दीजिए, फ्रेश बोल दीजिए दिस इज वी जस्ट amend the act or whatever. एक्ट बना है, रूल नहीं बनाइएगा, इसके लिए ऑर्डर चीफ कोर्ट का.
Item 63, Contempt Civil 78 of 2025.
Yes, petitioner.
This is regarding the payment of retirement in areas of salary grading. The order has not been complied.
Just come up for the first time. Yes.
So you will file compliance report. Every order has two parts. One is the direction and other is the time frame. If an order is not complied within time, you are already in contempt. So you should not be saying it is coming for the first time. Correct? Time has expired, you have not complied. So prima facie contempt is made out. How much time do you need? 4 weeks बहुत ज़्यादा है. अभी एक कौन से कुछ केस में ऑर्डर किए ना, कौन सा 7 फरवरी का कर रहे हैं ऑर्डर, ठीक है. Contempt Civil 78 of 2025. Counsel for the parties are present. Counsel for the opposite party prays for time to file compliance report. Post this case on 7th of February 25. Compliance report be filed by 5th.
For final disclosure, item 1, second appeal 110 of 2017.
Pass over this case.
This has not been admitted. है तो admit तो है. इसको pass over चाहिए.
Pass over for one matter. Mr. S.K. Sharma is engaged in this case.
अच्छा सुनते हैं तब. पास ओवर को आ जाएंगे, खुद ही आ जाएंगे. आ जाएंगे वो, पता है आ जाएंगे वो. किसी कोर्ट में बिजी होंगे, बताइए. Yes, respondent. The appellate court has not met with the reasons of the trial court. The appellate court has not met with the reasons. आपने substantial question of law देखा है? आपने substantial question of law देखा है? बताइए. Item number 1 का part बताइए. The appellate court has reversed the decree without meeting the reasons of the trial court. आपको क्या बोलना? वो ऑर्डर था ना, आप ही का था, किसका था? एक ऑर्डर उसका राकेश जी ने लिया था. राकेश जी को पता है, इसी पर हम लोगों ने ऑर्डर किया है. बताइए क्या बोलना है आपको? इतना काफी है ना? ट्रायल कोर्ट एक रीजन ऑर्डर किया, एपलेट कोर्ट भी एक रीजन ऑर्डर किया.
My lord, in a peculiar manner, the trial court had passed the orders without considering that the suit was filed for declaration of title and delivery of possession for a piece of land. The title deed of the said land finds mention only one boundary, whereas your lordship will find that the suit land filed by the plaintiff finds mention two plot of land A and B with two different boundaries to each other, which cannot be imagined, and therefore the appellate court questioned the correctness of the order on the ground that the suit land was not ascertained.
So they
No evidence was laid.
kindly show from the appellate court judgment that the appellate court interfered with the findings of the learned trial court because of this reason.
Madam, I'm
Show me the appellate court's judgment.
I'm just referring, madam.
अपील का जजमेंट बताइए,
बोलो,
खाली ट्रायल कोर्ट के फाइंडिंग्स का डिस्कशन बताइए,
वही बता रहा
तो पॉइंट नंबर 1 आंसर्ड हो जाएगा, ठीक है?
बोलो। क्यों बता? Para 10, running page 17 to 19 of the judgment of the trial court.
ट्रायल कोर्ट नहीं, appellate कोर्ट से बताइए। आप मेरी बात को समझिए पहले। appellate ट्रायल कोर्ट ने एक रीजन जजमेंट पास किया, एक जजमेंट पास किया ट्रायल कोर्ट ने। appellate कोर्ट ने ट्रायल कोर्ट की डिग्री को रिवर्स कर दिया। तो appellate कोर्ट को बोलना पड़ेगा ना कि भाई ट्रायल कोर्ट ये गलती किया है ना? ट्रायल कोर्ट का ये फाइंडिंग गलत है ना? कहाँ डिस्कशन है appellate कोर्ट?
वही दिखा रहा है।
तो आप ट्रायल कोर्ट मत दिखाइए, पहले appellate कोर्ट।
वही दिखा रहा है।
उनके उनके उसमें डिस्प्ले होगा, उन लोगों के पास कंप्यूटर है, वहाँ डिस्प्ले होगा, करके दिखाइए। इन लोगों को कंप्यूटर सिस्टम में ये प्रोवाइड करिए ना, कोई भी चीज़ देखना चाहते हैं कितना प्रिंट निकाल के देंगे। ये ना थोड़ा सा पुराना ऑर्डर है, उससे निकल जाता है, उसको थोड़ा सा ठीक से टैगिंग करना चाहिए.
Page 10
Page 10.
of the trial court, appellate court judgment.
Page 10. Right?
Paragraph 10. On hearing both the parties, perusal of case record and on careful examination of oral and documentary evidence adduced by the party, I find issue number 4, 5, 6 are important issues which have to be examined in the light of judgment and decree passed by the learned court below. In this case, moot point of determination whether the suit land mentioned in Schedule B of plaintiff part and parcel of 77 dismissal of land purchased by plaintiff by sale deed dated 18/10/54 Exhibit C1 and 6/11/68 Exhibit C, or whether the suit land is part and parcel of 98 dismissal of land purchased by defendant by sale deed dated such and such and sale deed dated 17/11/68. Plaintiff filed title suit number 152/18 for the possession of title to the suit land mentioned in Schedule B of the plan and recovery of possession of the suit land by dispossessing the defendant through the process of law. Plaintiff's case is that 77 dismissal of land was purchased from Messrs. Bihar Mines Limited through registered sale deed dated such and such, which was purchased land of Messrs. Bihar Mines Limited from Hirji Premji Parmar by virtue of registered sale.
These are all the case of the plaintiff, case of the respective parties.
और जो इसी में आगे हुजूर के लिए जो हम हुजूर के सबमिट किए हैं, that has been my lord.
हाँ बताइए कहाँ लिखा है कि
वही पढ़ रहे हैं.
हाँ, ऐसा पूरा मत पढ़िए आप, जहाँ पे डिस्कशन है खाली बताइए, उतना ही काफी है.
वही दिखा रहे हैं.
पेज नंबर 13 में बॉटम
हुजूर पेज 12 का पैराग्राफ 11 का नीचे हुजूर जमीन बोरहन चंद्रवाली मुकीम so from above facts it is apparent that the land of plaintiff with compound wall adjacent to west to 98 dismissal of land of defendants and burden was upon the plaintiff respondent to prove that there exists a strip of land, Schedule B land, between the land of plaintiff and defendant. But plaintiff failed to prove this fact by oral and documentary evidence. So, considering above fact, I find that pleading of plaintiff has not been established by cognate and convincing evidence which creates doubt over the claim made by the plaintiff. Further, I find from material available on the case record that defendants had purchased the suit land from Hirji Premji Parmar in the year 1940, constructed tiled room over the same, and defendants are claiming possession over the suit land for more than 20 years back, and also claiming adverse possession over the same. Report of two surveys, this is very important, my lord, on my lord's consideration, my lord. Appointment of report of two survey knowing commissioners is also on the case record, who went to the PO, inspected and submitted its report with map, field book, etc. And on perusal of judgment and decree passed by the learned court below, I find the report of both service commissioner has not been properly appreciated. Moreover, even if the plaintiff case is believed to be true that defendants are trespassers over the suit land and constructed room over the said land on 12/6/75, then what prevented the plaintiff to report the matter to competent authority regarding illegal trespass made by the defendants, and after a long delay, the instant suit has been filed in the year 1980, for which no explanation has been given for delay in logging the instant suit in the year 1980. after a long gap of 5 years and on completion of boundary of Schedule A and B land, further it appears that the boundary of Schedule B land could not be established by the plaintiff respondent, which creates doubt over the plaintiff case that Schedule B land is part and parcel of Schedule A land. Further, I find much substance in submission of the appellant that learned court below has wrongly relied upon the report of Survey Knowing Commissioner Nageshwar Prasad Sinha, who was not appointed by the court, and illegally discarded report of Survey Knowing Commissioner Narayan Rai, who was appointed by the court. Commissioner Nageshwar Prasad Sinha has admitted in his evidence that he has not measured the whole plot of 669 and he has privately measured the land at the instance of plaintiff and none was made witness to that. So, court below has wrongly relied upon biased report of Commissioner Nageshwar Prasad Sinha, whereas report given by Narayan Rai was not properly considered by the court below. Further, I find the learned court below has also not properly considered Order 26, Rule 10, Subclause 10(2) of CCPC, according to which report of Commissioner and evidence taken by him shall be part of the record. So, considering all the above facts, I find that the court below has wrongly decided issue number 4, 5 and 6 in favor of plaintiff and came to wrong conclusion that plaintiff had subsisting right title to suit land. On perusal of judgment and decree, I also find that evidence of witnesses examined by the defendant appellant has not been properly considered. My lord, 2 points are very crucial.
Let us see the finding of the learned trial court.
My lord.
With respect to issue number
4, 5 and 6.
4, 5 and 6. ये फाइंडिंग है पेज नंबर 43. पढ़िए.
Okay.
पैरा नंबर 12 से पढ़िए पेज नंबर 61.
Findings will.
हाँ, यहाँ से पढ़िए आप प्लीज.
हाँ.
यहाँ से जस्ट अ मोमेंट. Page number 52, internal page 19 of the trial court. 19, 19, 19 का बॉटम है. In my opinion,
running page of the
या पैरा 9 से पढ़ लीजिए. Having considered the documents, internal page 16.
having considered the documents of the party,
उसके just ऊपर थोड़ा सा एक दो sentence.
so you,
I would like to.
I would like to say that the
Yes. Further, I want to say
contents
that.
of Exhibit B and B1
Yes.
are not binding
Yes. आगे पढ़िए.
on the plaintiff. Again, I would like to say and emphasize upon that there is a mention of 20 dismissal in as part property in Exhibit B1. This
There
is
is
not,
no mention.
This is not there, madam. This goes to show that this woodland, which is parcel of 20 dismissal, does not belong to the defendant. My submission before your lordship is that such description of land is imaginary in the order. That does not find mention in this shell deed itself. The strip of land, I will be out of the court if any mentioning of Schedule B land finds mention in the title deed, which has been made basis for this suit. That is not there.
Schedule just बताइए. Schedule A and Schedule B का क्या
हो जो उनका प्लेन का कॉपी देखा जाए, उनका प्लेन कहीं है ही नहीं. That is a strip of land, that is imaginary for the purpose of laying claim over the land of the appellant.
So your contention is that Schedule B land was never a part of Schedule A land. This is your entire case.
This was the case which was made by the plaintiff. This is not my case.
आ गए हैं अपीलेंट.
हुजूर,
बताइए. इनका कहना ये है कि जो क्वेश्चन ऑफ लॉ पहला बना था, he has read the appellate court's judgment and he has placed the discussions regarding the as to how and why the court is differing with the findings which has been ultimately arrived at by the learned trial.
But so far as the oral evidences are concerned.
No, you see there are two questions of law. One was framed that the appellate court has not discussed the reasons given by the learned trial court. So there is a discussion in the body of the judgment.
Discussion is there, but the reasoning which was assigned by the trial court, that has not been met.
Okay.
That is the first question. Second one was that the court was justified in not considering any oral evidence. So the entire judgment of the appellate court, no oral evidence has been discussed, which were the material evidences, which was the basis for the decreeing the suit. So while reversing the judgment, the learned appellate court failed to discuss those evidences, which are the relevant evidences on the basis of which the trial court has decreed the suit. Let me, my lord, show those evidences.
You just see the learned trial court has himself mentioned that although number of witnesses were adduced, 11 witnesses,
yes,
out of which PW 1, 2, 3, 9 and 10 are formal witnesses,
yes,
and they have proved the documents of the plaintiff,
well,
about which he has commented earlier,
yes,
and he has discussed the evidence of PW 4 and PW 5, PW 8 perhaps.
So far as the appellate court, your lordship may kindly see the appellate court.
Whose evidence has not been considered?
Yes, I'm placing that evidence.
And what difference would have that evidence made? out of the 5 issues, which issue is relevant according to you? Issue number 3. There was no issue of adverse possession.
No. The learned appellate court claimed one point of determination. Let us see first, my lord, what is the point of determination claimed by the court. Para 10, your lordship may kindly see that page 10.
Yes.
On hearing both parties, perusal of case record, and on careful examination of oral and documentary evidence produced by parties, I find that issue number so and so are important issue which has to be
There is no
examined in
issue
light
number
of-
6. There is no issue number 6 in the trial court judgment. There is only issue number 1 to 5, as recorded in the appellate court's judgment itself, in page number 5. Although the trial court has perhaps framed more issues,
There are altogether 8 issues. by
8
the trial.
issues which has been wrongly recorded in the appellate court's judgment, that there were only 5 issues.
8 issues.
Okay. Yes, please.
Issue 5, 4, 5, 6 are important issues which has to be examined in the light of the judgments and judgment. It is the case moot point of determination whether the suit land mentioned in the schedule be part of the plant is part and parcel of 0.77 decimals of land purchased by the plaintiff by its dated 18-10-54 Exhibit C and 6/11/1968, or whether the suit land is the part and parcel of 98 decimals of land purchased by the defendant or dated such and such and the dated such and such. So this is basically the issue. My point is that the suit land is the part and parcel of the property which I purchased, and they are saying no, that is their part. Learned trial court has examined the deed, and in the deed in the boundary, it is in the boundary itself. It is written Chauhadi Mohiran. That part I will be placing, which shows that when in their deed it is written. It is their deed is written, which shows that it was the person who later on sold to us. He was in the possession of the relevant point of time. And
Jharkhand Mokuran matlab?
let me
What does that mean? What is the meaning of this term?
I'm placing that.
Jameen, Gorhan.
पश्चिम जमीन बरान चारदीवारी मौकीर
इसका क्या
चारदीवारी
मतलब है?
मौकीर
इसका क्या मतलब?
मौकीर का मतलब हुआ है जो बेच.
So it was a bounded land.
ये
It had
जो परचेस किए हैं उसके पश्चिमी पार्ट में इसका बाउंड्री था जो इनको बेचा. बाद में हमको जो बेचा तो जब उसका अपना बाउंड्री था तो उस पार्ट में अगर कोई जमीन वो बिक रही है तो उसमें तो मेरा ही हुआ, इनका कहाँ से. अदरवाइज अगर इसमें अगर इसका अगर कुछ वेस्टर्न पार्ट में कोई डिफरेंट बाउंड्री होती तब इसमें इनका हो सकता था. इस बात को कोर्ट ने भी कंसिडर किया और अपीलेट कोर्ट ने इसको जस्ट रिवर्स समझा. एक तो इसमें इंटरप्रिटेशन का भी मामला था, उस दिन में हमने कहा था, लेकिन इसके अलावा जो ओरल एविडेंस है जिसके बुनियाद पर इनका कहना था कि नहीं हमारा बंटवारा हो गया है और इनका कोई भी जो कि दूसरे जो इनके भैया थे वो इनको सपोर्ट करने नहीं आए, और जो भी ये सब एविडेंस है ये सारे एविडेंसेस को ट्रायल कोर्ट ने कंसिडर किया और कंसिडर करने के बाद कहा कि नहीं इसमें आपका जो है सो नहीं है, इन पार्ट को हम जो प्लेस इशू नंबर 4, 5, 6 देखा
ट्रायल कोर्ट
trial. Have the plaintiffs got right title interest over the suit land described in A of the plaint with the story of disposition?
Just a moment. Issue number, has the plaintiff got right title and interest?
Most
Is-
important part.
Yes.
Is the story of disposition from suit land as alleged by plaintiff correct, and whether he is entitled for recovery of position? Have the defendants perfected title by virtue of it? They have raised.
जब वो एडवर्स पोजीशन का प्ली ले रहे हैं तो आइडेंटिटी ऑफ द प्रॉपर्टी में नॉट बी इन डिस्प्यूट
होना नहीं चाहिए। और भी है, जो एडवर्स पोजीशन का प्रॉपर्टी का प्ली तभी ले सकते हैं when that is in his position, otherwise there is no concept of adverse position। और दूसरा उतना ही नहीं है, एडवर्स पोजीशन का अगर ये प्ली लेंगे तो इनको ये बात बताना पड़ेगा कि ये ज़मीन किसकी है, आप कब से ये इस पोजीशन पे आए और ये पोजीशन कब एडवर्स हुआ। ये अगर इनका प्लीडिंग नहीं है तो सिर्फ merely for just for taking a plea will not work। इसमें relevant parts
चलिए फाइंडिंग पढ़िए,
दिखाते हैं।
फाइंडिंग एकदम तेजी से पढ़िए।
But these issues are interrelated with each other. Therefore, they are taken together for adjudication for sake of convenience. I have stated above the facts of the contesting parties from which it is evident that the plaintiff claims title to the suit land. They have also claimed that the suit land is the part and parcel of the purchased land measuring 77 decimals out of plot number 669 of Isri Bazar, PS Dumri, and they have also claimed that they were coming in possession of the till they were disposed on 12/6/75 from the suit land by a defendant who had constructed a tiled house on 2/3 decimals. The case is also that the vendor Bihar Mines Limited was in possession of it prior to the purchase, and prior to that, G. Premji Parmar was in possession of it. They have also stated that they are in possession of the rest land. On the other hand, the defendants also have claimed that the suit land is part of their purchased land measuring 98 decimals, and they have constructed their house on 78 decimals. And this land, along with 18 decimals of land, were left jointly in the possession of their co-sharers. This is the stand they have taken. The case is that the house of the disputed land was constructed 20 years ago, and they have their co-sharers have been coming in possession of it since 1940. They have refused and denied the alleged story of disposition and construction of house on it. They have also denied the possession of plaintiff on it. Thus, from the facts stated above, it is evident that the plaintiffs have claimed their title on the basis of sale, so that it is governed by the Article 65 of Indian Limitation Act, and plaintiffs have to prove their title on the suit land. It is clear from the pleadings of the parties that the plaintiff stand in their pleading that they have dispossessed from the suit land. In view of the matter, I would like to consider the documents of the parties first of all. First, take up documents of plaintiffs. Exhibit 1 series and rent receipts of the plaintiff in the name of plaintiff number 1. It is evident that they have been paying rent for the suit land along with the other land. Exhibit 2 is the Chaupidari receipt. Exhibit 3 is the field book of the commissioner who measured the suit plot along with the suit land. Exhibit 4 is the report of the commissioner, and Exhibit 5 is the map prepared by the commissioner. It will be discussed. His report, I will discuss his report at later stage while considering the report of the commissioner appointed by the court. Exhibit 6 is the sale deed executed by Messrs. Bihar Mines Limited in the favor of plaintiff on 4/11/1968, which is the basis of our claim. It is clearly goes to show that Messrs. Bihar Mines Limited had sold plot number 669 and 667 and other plots to the plaintiff on 1968, and boundary given it also goes to show that the ancestors of the defendant had purchased the eastern land in this plot. It also goes to show that the vendors of Messrs. Bihar Mines Limited were Himji Premji, Exhibit 6A, It also goes to show that the northern boundary of the plot 669 purchased by plaintiff has been shown as GT Road. There is no house, there is no case or evidence on the side of the defendant that the boundaries given in this schedule are wrong, and also the boundaries described in the Schedule B of the plaintiff are also wrong. It is stood admitted that the specifications of the suit land described in Schedule B is correct, and defendants cannot be allowed to dispute it. The fact also admitted and corroborated by the schedule and the other documents of the defendants. Exhibit 7 is the CC of suit register of Munsif Court, Giridih. It has been filed to show that the Chotelal Barnwal has filed TS 75 dated T775 against the defendant number 1. That suit was compromised and the suit was dismissed. The intention of the plaintiff is that the said suit was with respect to a portion of 20 decimals of plot number 669, and they have succeeded in eviction suit. In other words, when the defendant number 1 had accepted the title of the Chotelal on the part of 22 decimals, then cannot be allowed to say that his co-sharer has left 22 decimals jointly in 1950. In my opinion, it cut the roof of the defendant case. Surendra Prasad, DW6 has denied in para 12 of the evidence that Chotelal Dharwal had 5 title suits, but his falsified proved by the Exhibit 6 referred to. According to his evidence in para 11 of para 11, Kalpana Hotel is there for last 20 years, and his uncle's does not get rent, whereas the plaintiff in his evidence has asserted that the Kalpana Hotel belongs to him and he gets the rent. It is settled principle of law that if the possession of a title, possession or title of a person is found on the part of the land, then the possession and title will be presumed to be the whole. Exhibit A to A by 6 are the rent receipts of the defendant and Laleshwar Prasad for 13 decimals and 12 decimals of plot number 669 of Iksiri Bazaar. About there is no dispute. Exhibit B is the deed of partition among the brother of the defendant. This deed for properties described in Schedule G have been allotted to defendant number 1. This partition took place in 1972. It is apparent from page 28 of Exhibit B that Surendra Prasad, defendant number 1, was given 13 decimals out of 6 plot number 659. Entries made in para 228 with respect to land of defendant number 1 goes to show that the 20 decimals was not left in goes to show that 20 decimals was not left in joint possession of his brothers and uncles. Hence, the western boundary of the land has been described as Laleshwar Prasad. Defendant number 1 has pleaded in his WS that he constructed a suit house with the consent of the co-sharer and uncles, but his uncles has not come forward to support his case that 20 decimals was left in joint possession in accordance with the deed of the partition. This has been shown in Exhibit E by 1. In my opinion, these two deeds of partition do not support the case of the defendant in unity. Moreover, Exhibit B by 1, there is an apparent and manifest interposition in page 28 that Surendra Prasad's father was allowed to 24 decimals out of purchases in 1998. 5 decimals have been added for the purpose of this suit in para 28. Exhibit C is the schedule executed by Hirji Parmar in favor of the ancestors of the defendant in 1940. By deed, predecessor in interest of the defendant has purchased 98 decimals out of plot number 669 with a definite boundary. In the deed it has been mentioned that is in the western boundary as follows: Paschim Dhoran Chardiwari Moki, means thereby that the lands of the vendor of the ancestors of the defendant fell in the western side of the purchased land measuring 98 decimals. In my considered opinion, this suit land is the part of 20 decimals which belong to the acquired land which landowner, Giji Parmar, which was sold to Messrs. Bihar Mines and later on sold to these plaintiffs. Exhibit C/1 is the sale deed executed by Rajendra Prasad Barwal in the favor of Dhaneshwar Prasad. This sale deed is not relevant for the purpose of the suit. The relevancy was not disclosed during the trial. Further, I would like to say that the contents of Exhibit B and B/1 are not binding on the plaintiffs. Again, I would like to say that and emphasize on that there is no mention of 20 decimals in the part property of Exhibit B/1. This alone goes to show that the suit land, which is part of 20 decimals, does not belong to the defendant. Had it been so, must have been mentioned in the Exhibit B/1 as the property of the defendant and his co-sharer. Having considered the documents, I feel inclined to accept the case of the plaintiff that they have subsisting title to the suit land, and I hold that it is the part of the land purchased by the plaintiff in 1968 from Mr. Bihar Mines Limited. Exhibit 5 is the report of the commissioner appointed by the plaintiff, whereas Exhibit D is the report of the commissioner appointed by
This
court.
is in connection with possession.
Yes.
Exhibits.
No.
This one, pleader commission.
Pleader. Two commissioners' report are there. One on behalf of the plaintiff, and another, that is Exhibit D, it was appointed by the court. According to the report of the commissioner appointed by the plaintiff, the suit land is the part of the purchased land of the plaintiff, whereas report D says that it is the northern part of the plaintiff. Let us see what the law on the point, whether the court is bound to accept the commissioner's report as a gospel truth, leaving aside the reliable evidence on record. Order 26, Rule 9 and 10 CPC provide for commissioner to make local investigation, and the procedure for commissioner is provided under 26 Rule 10 CPC. With the provisions do not say that the report of the commissioner is binding on the report. Rather, report of the commissioner is to assist the court. I had confirmed the report of commissioner appointed by court with these observations that the report D, Exhibit D, is subject to the scrutiny at the time held along with the other evidence to be adduced by the parties. The learned counsel for the plaintiff has submitted that the report of the first commissioner appointed by court on this clear that the gate of the plaintiff is in existence on the south of the suit land, and the same belongs to plaintiff. And this fact, though denied by the defendant, is proved by a report Exhibit D. The learned counsel has also invited my attention to both reports and submitted that the both commissioners have committed mistake by not measuring plot number 669 as a whole in order to find out whether the suit land is part of the land of the plaintiff or of defendant. He frankly submitted that the both reports are fit to be rejected on the point whether the suit land is purchased land of plaintiff or the defendant. In support of his contention, he has placed reliance on a decision in AIR 1970 Masood, page number 314, where it has been held that local investigation delay the commission, rather order 26 Rule 9 is merely to assist the court by placing the report of such investigation before the court. Such report is not in any way binding on the court, whose power to arrive at its own conclusion, or even as with such report. It is to say, stated by such report, the learned counsel for the plaintiff has also submitted that this suit cannot be decided solely on the basis of the report of the commissioner. Rather, his report is subject to objection and outcome from its own opinion and of the other evidence. In support of his contention, he has placed reliance on a decision reported in AIR 1953 Patna at page 123, where it has been held in para 5 that the order rejecting of objections or confirming the report of commissioner does not mean that the court has dictated its function and has decided a fact in issued solely on the report of the Commissioner and in advance or in respective of any other relevant evidence bearing on the purpose. In my opinion, there appears to be substance in this submission and is fit to be relied on, and I have perused the report in minute details, and both committed vital mistake in not measuring the whole plot 669, and however, of all defendants and other passengers in plot 69, and evidence adduced on the suit to show that the suit land is part of the land purchased by the plaintiff and their possession prior to the alleged disposition. Now let us consider oral evidence from the part of position. First of all, I would like to take up the oral evidence of defendant. Altogether, 6 witnesses have been examined on behalf of the defendant. Surendra Prasad is one of the defendants who has been examined on behalf of the defendant. He has stated that the ancestor has acquired 98 decimals of plot number 669 of Visiri Bazaar from Hirji Parmar. He has stated that they constructed their houses 98 decimals which were divided in the brothers, and 20 decimals were left as party and 20 decimals remained joint. He has stated that the suit land is the extreme western portion of 20 decimals, and there is not the case of the plaintiff that it is the extreme eastern portion of 20 decimals. He has stated that he has constructed 2 rooms in the disputed land, and 22 years ago, and there was no gate south of the suit land. He has also stated that the vendors of the plaintiff were never in possession of the suit land. He has also stated that the plaintiff and others have always are also purchasers of the plot. He has also claimed that he left the land west of the suit land. He denied the case of the plaintiff. He has been strenuously and thoroughly cross-examined by the plaintiff, and he has stood the best of cross-examination. He has stated that in para 6 of his evidence, the vendor of the plaintiff has no wall land on western side of the house, and as the same has been admitted, the boundary given in the city is correct. He denied to have deposed falsely. He has also admitted that he has no land west of his purchased land. He has admitted that his 98 decimals was in the straight line toward the west, and the land of the Hirji Parmar was also in the straight line. This goes to show that this 22 decimals of 2.5 decimals is the part does not belong to plaintiff. The part themselves has not been clearly described in the commissioner who has measured the land on the part of the plaintiff. Because according to DW6, the boundaries given in the state deed is correct. Then the suit land cannot be the part of his land. He has not made out a case that the boundary given in the state deed is incorrect. He has further stated that his father has got 24 decimals in partition in 1958, and after that, on the western side, the land of his uncle falls. This how can he construct the rooms in the suit land when it belongs to his uncle? His uncle has not come forward to say that it belongs to him. There is no case in the whole WS that the 5 decimals was left as a rasta in which the suit land falls. No suggestions has been thrown to the plaintiff that the 5 decimals were left for rasta by the defendant. His evidence in para 8 is totally false and beyond the pleadings. His further evidence in para 10 is beyond the pleadings, and hence he has stated that the plaintiff had encroached upon 18 decimals of his 20 decimal and constructed a house, and now he denied his averment on oath. According to his pleadings, plaintiff are in possession of 18 decimals of which the suit land is part. He cannot go beyond his pleading, and so he stopped from challenging the position of the plaintiff. On the basis of doctrine of non-covered, it goes to show that the plaintiff were in possession of the suit land prior to 1976, and the defendants were never in possession of it, and they met encroached upon the land of the plaintiff in 1975, and thereafter they have constructed the suit rooms. This further evidence in para 11 goes to show that there is a hotel in 20 decimals which does not belong to him, and then how can he claim these 20 decimals which were left jointly, and when there is no partition among these co-sharers, then how can he construct room on the suit? Plaintiff has claimed this hotel belongs to him. He has admitted in para 11 of his evidence that hotel is there for last 20 years, so the plaintiff was in possession of it for more than 12 years. His evidence in para 12 is false. Why had the defendant construct the room in the suit land? Due to the fact that the value of the land is increased due to its development. In view, I hold that DW6 has not been able to prove his possession for more than 12 years. Abhay Barnwal is resident of that place. He belongs to caste of defendant. He has stated that suit land measuring 2 by 3 decimals is the part of the land of the defendant. He has stated that the defendant has constructed a room 20 years ago, whereas the defendant number 6 that the rooms were constructed 22 years. There is variance in the two statements. He has come to say that the house of the defendant is over 78 decimals and 20 decimals towards the west of their house belong to the defendant. 2. He has stood the test of the cross-examination. He is aged about 35 years. He stated in para 2 of his evidence that he has attained age of discretion 20 years ago. According to his evidence, when he saw the land 20 years ago, then it was a party. So the statement of this defendant in DW6 are false, that the rooms are there for last 22 years. In other words, the stand of the plaintiff is correct, that it was a party land used for stealing, coming and passage through the whole lands to the gate. He supports the case of the plaintiff in para 2 of his evidence. He also stated that there was a tea store prior to the plaintiff's shops. Rameshwar Prasad DW3 is interested with. He has come to support the case of the plaintiff. He has stated in para 4 of his evidence that there is a party land between the house of the defendant and the suit land, but there is no such use. He is here several months. His evidence in para 9 further goes to show that he has no idea of the suit land. He has admitted that he has not seen any paper from which he can say that the house of the defendant over are 78 decimals. Shiv Shankar Prasad Swarnkar DW4 is also aged about 35 years. He has stated that the defendants have constructed the suit rooms 20 years ago and there is no gate south of it. He has denied the possession of the property. He has deposed in para 2 of his evidence that he has been seeing the suit rooms before they attained the age of his.
So the possession of the defendant was negative.
Yes, and after a very detailed discussions of all the evidences available on record of plaintiff as well as the defendant. Later on, we have discussed the evidence of plaintiff also. And then he has come to a finding that is at page 60, internal page 64, at page 31. May I read further?
Yes.
Yeah.
Page number 31.
That is the final finding.
Yes. Para 14.
Yes.
The pleader commissioner's report has been considered in para number 13.
Pleader commissioner's report has been considered, and after Leonard trial court says that the both
Is fit to be
reports are
rejected.
not to be relied upon. Not to be relied upon.
Because earlier there is
The
a discussion
reason
that they did not measure the entire area of, and the entire dispute was, it is something like if a particular plot consists of 10 decimal, then the part can be assessed only when, if there is no definite boundary given, then the part can be assessed only if the entire land is measured.
Yes.
unless the entire land is measured, it may not be possible to figure out as to whether this particular property is falling under this particular plot.
Yes.
That is the reason given.
That is the reason. But I am just reading the final part. I hold that the plaintiff are purchasers of the land and they have got title to the suit land and they have illegally disposed in the year 1975. These issues are decided in the favor of plaintiff and against the defendants.
What the appellate court has done, according to you? There is no discussion of oral evidence?
No.
Completely?
Completely. Your Lordship may kindly see, madam.
Para 10.
First of all, I would like to show the para 1 and para 2. These are the case of the party.
Yes, para 1 and para 2 are the case of the parties. Then the issues framed.
Issues
Para 4 they have
para 4
partly
discuss
written.
किए।
वो issue para 4 में लिखे हैं लेकिन पूरा नहीं लिखे हैं।
पूरा भी उसमें
पूरा नहीं लिखे हैं।
उसमें भी कमी।
3 इशू
5 में बताए हैं कि कौन-कौन सा विटनेस वगैरह एग्जामिन हुआ, क्या डॉक्यूमेंट्स ऑन रिकॉर्ड है। 6 में हम लोग के बारे में बताइए, अपने बारे में डिपेंडेंट के बारे में बताए हैं कि कौन-कौन सा डॉक्यूमेंट इन्होंने इसका खाली एक लिस्ट दिया है। उसके बाद 7 में लिखते हैं कि आफ्टर हियरिंग द पार्टी कंसीडरिंग द मटेरियल अवेलेबल ऑन रिकॉर्ड लर्नर कोर्ट डिग्री विद कॉस्ट, उसके बारे में
Then heard both sides.
8 से शुरू किया है फाइंडिंग। Heard the parties and perused the case. It has been submitted on behalf of the appellant asserting the judgment and decree passed by the court for contrary to.
These are the submissions.
इसमें भी ये सबमिशन इनका लिखा है। ये सारा सबमिशन लिखे हैं। सबमिशन लिखाने के बाद पारा 8 में रेस्पोंडेंट का सबमिशन लिखा है।
Para 8 में. Yes.
पारा 8 में लिखा है।
Plaintiff का submission para 9 में है.
हाँ, रेस्पोंडेंट का पारा
Para 9 is a submission of the plaintiff.
पारा 8 में उनका है, डिपेंडेंट का है।
हाँ. Para 9 में plaintiff का. Para 10 में findings.
पारा 10 में फाइंडिंग पढ़ते हैं।
वही पढ़िए.
On hearing both the parties, perusal of case record and careful examination of oral and documentary evidence adduced by parties.
This you have already read. Next para पढ़िए. Plaintiff file title suit. ये तो हो गया para 11 पढ़िए.
Considering submission of the parties going through the judgment and decree passed by the learned court below, as well as perusal of the materials available on the court, it is the admitted case of the party that the adjacent rest to the 38 के जगह 98 होना चाहिए. Decimals of dependent ancestors purchased the 98 decimals through the registered deed, and the remaining 77 decimals were purchased by plaintiff, which is the western adjacent west to the 98 decimals. Total area of plot is 669 up to 2.13 acres. The ancestors of Mahesh Lal Prasad and Jamna Prasad purchased total 38 decimals of extreme portion of 669 by 2 different deeds. So accordingly, total 2.13 decimals of land was sold by H.G. Parmar to the defendants and the plaintiff. It is admitted by plaintiff that H.G. Parmar constructed buildings and factories over 669 with compound, and is also admitted that in the said deed, western is mentioned, western Jameen Ghoran Chardiwari Moki. So from the fact, it is apparent that the land of the plaintiff is compound wall adjacent to west of the defendant, and the burden was on the plaintiff to prove that there exists a strip of land with the land of the plaintiff and defendant, but defendants failed to prove this fact by oral and documentary evidence. So, considering above fact, I find that the pleading of plaintiff has not been established by close present and his convincing evidence, which creates doubt over the claim made by the plaintiff. Further, I find that the material available on the case record that the defendant had purchased the suit land from H.G. Parmar in 1940, constructed tile rooms and same, and defendants are claiming possession for more than 20 years back and also claiming adverse possession for the same. Report of the two defendants, report of the two survey knowing. Survey knowing commissioner is also on is on the case report who went to PO, inspected and submitted this report with map, field book, etc. And for result of the judgment and decree passed by the court, I find the report of both the commissioner has not been properly received. Moreover, even if the plaintiff case is believed to be true that the defendants are trespassers over the suit land and constructed room said land on 12,670 feet, then what prevented the plaintiff to report the matter to the competent authority regarding illegal trespass made by the defendant after a long delay? The instant suit has been filed in the year 1980, for which no explanation was given for the delay in lodging the instant suit in the year for a long gap of 5 years.
That is nobody's case.
That is not totally irrelevant, because if suppose I had it been after 12 years, it could have been barred by the delay in documentation. It is within limitation time.
No finding of adverse possession has been given.
No. ये ज़्यादा इसी पर गए हैं कि कोर्ट वाला रिपोर्ट पर ही ज़्यादा गए हैं और लिखा है कि वो रिपोर्ट उन्होंने कंसीडर नहीं है, जबकि ट्रायल कोर्ट ने दोनों रिपोर्ट कंसीडर.
But the plaintiff failed to prove this fact by oral and documentary evidence. This is the only consideration of oral evidence.
सिर्फ ऐसे ही लिख दिया था.
There is no consideration of any of the oral evidences.
No, not at all. और भी जो एक डिस्कशन होना चाहिए एक डॉक्यूमेंट्स का डिस्कस करने का, क्योंकि हाँ ये डॉक्यूमेंट का क्या लीगल कंसिक्वेंसेस है. हमारा डॉक्यूमेंट हाउ इट इज नॉट फेवरिंग मी, जो कि ट्रायल कोर्ट ने किया, उस चीज़ को इसको उसका रीजन को भी मेट करते हैं.
So according to you, what is to be done?
Yes.
According to you, what is to be done?
It has to be remanded. Because there are judgments to that effect कि अगर रीजनिंग अगर इसमें नहीं है तो उसको.
उनका अपना रीजनिंग है, लेकिन ट्रायल कोर्ट ने जिस रीजन से प्लीडर कमिश्नर के रिपोर्ट को डिस्कार्ड किया, वो रीजन को नहीं लिखे, वो प्लीडर कमिश्नर के रिपोर्ट पे चले गए, ओरल एविडेंस पे नहीं गए हैं. दैट इज नो डिस्कशन ऑफ ओरल एविडेंस एंड डिले इन फाइलिंग द सूट हैज बीन अ ग्राउंड taken by the appellate court.
But it is not legal.
It is not relevant according to you, right?
It is not legal, and because if there is suit for recovery of possession, the limitation is for 12 years. And if the cause of action, even if arose in 1975 and the suit was filed in 80, then it is well within time.
हाँ बताइए, सुन लिए इनको.
इसके अलावा एक चीज़ और हम कहना चाहते हैं, लीडर कमीशन का जो रिपोर्ट होता है, the lawsuit mechanism is
that will with me, that I will show. I will read before they are on the record. Both the reports are with me.
देखिए, आपकी रिपोर्ट को हम यहाँ पे पहली बार नहीं एग्जामिन करते.
I am not praying for it. I am not submitting before a lot.
Let us come one by one. Is there any discussion of oral evidences? Yes or no? Is there any discussion of oral evidence by the appellate court?
My Lord will kindly.
Or it is irrelevant?
My Lord will kindly appreciate my submission.
Yes, yes.
I have made only 3 submissions before your Lordship for consideration.
Yes.
Number 1, my Lord, that the plaintiff has miserably failed in establishing the identity of the suit land, and on the basis of prayer made by the parties, respective party, commissioner was appointed to ascertain the identity of the land, and according to the rules of the CPC, the report of the commissioner is a part of the record, and that has to be discussed in the impugned order passed by the trial court. From the perusal of the report submitted by the pleader commissioner, it will be crystal clear that the pleader commissioner appointed by the court, Narayan Rai, measured the entire area of land. Unfortunately, that has not been mentioned in the trial court judgment. And after, in presence of both the parties, therefore I am submitting before this honorable court. My lord, permit me to read the report.
I just
My lord. And it was ascertained that this Schedule B land, 20 feet strip of land, is not a part and parcel of the land purchased by the plaintiff. Therefore, what could be the basis for the trial court arriving at the conclusion that that strip of land belongs to the plaintiff, whereas the report of the pleader commissioner specifically finds mention that the said portion Schedule B land belongs to the defendants, and it has been found in presence of both the parties. Therefore, the erroneous finding, without discussing the merit of the plaint and the documentary evidence and the pleader commissioner report, the finding of the trial court was found wrong by the appellate court. And therefore,
one question. You said that as per the pleader commission reports, he had measured the entire land. Let us see, is it mentioned in the appellate court's judgment, or we have to see it from the pleader commission's report?
pleader commissioner
It must have been mentioned in the appellate court's judgment that the entire land was measured. Is it mentioned in the appellate court's judgment that the entire land was measured?
that is not there, my lord. Specifically, that is not there. The word is not there.
So therefore,
But the report is there, which has been marked as exhibit.
so that is the reason the appellant is saying that pleader commissioner, while considering the pleader commissioner's report, the trial court found that the entire plot, the area of the land was not measured of the particular plot, right? So while considering the pleader commissioner's report, the appellate court should have mentioned that this is incorrect.
My lord, but the trial judge, my lord, trial court, my lord, without giving reference to the report submitted by the pleader commissioner appointed by the court, declared them that both the reports are not trustworthy and that cannot be relied upon. This was the erroneous finding, my lord, of the trial court.
There is a discussion of trial court's report, in the trial court's
Discussion is there, my lord. But
The
what
trial
would be
court
the
judgment
legality of accepting the report submitted by the private pleader commissioner appointed by the
trial court
plaintiff?
has not accepted the report of the private commissioner also.
My lord,
He has discarded both the reports.
there
And-
could
and
not be
as-
justification for discarding the report of the
They
pleader
have-
commissioner
the
appointed
trial
by the court, my lord.
It is
Appointed by the
gospel
court,
truth.
my lord.
If the pleader commissioner appointed by the court does
Court.
not give a proper report, it is binding on the court.
Therefore, my lord,
So, therefore, the pleader commissioner's report, both the pleader commissioner's report has been
my lord, for
rejected.
the sake of argument, I may be permitted to submit, my lord. If the trial court was not satisfied with the report submitted by the pleader commissioner, that there was provision in the CPC, my lord, to appoint fresh.
What they would have
For
done,
the purpose of ascertaining the identity of the land, for declaring the title of the land which do not find mention either in the sale deed.
trial court will pass the order suo moto. No.
My-
Before the appellate court also you did not say that let a fresh pleader commissioner report be called for.
My lord,
There was no such step
Madam,
taken by either parties.
this was the contention which was raised before the appellate court, my lord. Everything which we made submit before the court, my lord, is not recorded, my lord.
So
The
that's
submission was there.
एक second just hold on. High Court will see only what is recorded. We will not see what is not recorded. Isn't it?
Therefore, on that basis, I am praying for this honorable court that the recording of judgment of the trial court without, my lord, establishing the identity of land is, my lord, absolutely illegal and erroneous finding. that is neither
If-
based on the documentary evidence
No,
nor
fair
on the
enough.
basis of the
Whatever you
Clear
are,
Commissioner's
you
report,
see,
my lord.
whatever you are submitting,
My lord.
is there any finding by the learned appellate court that the finding of the learned trial court that the pleader commissioner has not measured the land is incorrect? Is there any finding recorded by the learned appellate court?
That is not essentially required, my
Why
lord.
not
He has
required?
that he has discussed, my lord, with the report of the commissioner.
Show me
And
from the, just a moment,
mainly, my
show
lord.
me from the finding
My lord.
that the report of the commissioner as discussed by the appellate court reveal that the entire area of the land was measured.
Entire area of land, my lord, was purchased by two persons.
Yes.
Hirji Parmarji sold in favor of Bihar Mines. Bihar Mines was the executor of land in favor of the plaintiff as well as the defendant. 1940 में हमने खरीदा, 1968 में इन्होंने खरीदा.
आज नहीं हो पाएगा complete.
खोजो.
Essay number 110 of 2017. The arguments in this case has commenced, but has remained inconclusive on account of as the court time is over. Post for further hearing on Tuesday, Wednesday?
अगला वीक में हो जाओ.
तो अब कल रख दें क्या?
नहीं कल नहीं किया जाए. नहीं उसके अगला वीक में कर दिया जाए.
नहीं देखिए,
एक इलेक्शन
जस्ट अ मोमेंट, इलेक्शन है तो भाई ऐसा बात नहीं है ना. आप आधा चीज सुन लिया, फिर से पूरा नहीं सुनेंगे ना हम.
नहीं पूरा नहीं सुनेंगे.
नहीं, आप सामान आप टाइम निकाल के आइए, ऐसे नहीं होगा. इलेक्शन है तो कोर्ट बंद करने का कोई सर्कुलर निकलवाइए, कोर्ट बंद हो जाएगा.
पावर को हमको पावर
नहीं, हमको भी पावर नहीं है भाई, ये पावर आप ही लोग को.
हम लोग को नहीं है पावर. हम कभी पावर के बारे में नहीं जानते हैं. उनको पावर है.
साहब देखिए, इसको जो है ना इतना दिन नहीं पोस्टपोन कर सकते. बोलिए तो मंडे को भी रख सकते हैं.
केवल एक वीक के लिए.
नहीं, हम भूल जाएंगे. अरे भाई, मेरा भी तो मेमोरी का एक लिमिट है ना.
ठीक है.
हम तो डे टू डे सुनते हैं. कल होता तो कल ही सुनते. ट्यूसडे को रखते. ट्यूसडे को कितने मैटर्स हम लोग रखे हैं? है हम लोग का कितना?
फर्स्ट डे हम
एक कितना? 3 मैटर. ट्यूसडे को इसको हम लोग रखते हैं 12 बजे. नहीं, सेकेंड हाफ में चाहिए. बताइए कब चाहिए?
जब हुजूर को
12 बजे.
हुजूर
ठीक है.
बिल्कुल ठीक.
ओके,
बिल्कुल ठीक.
For further hearing on Tuesday at 12. इलेक्शन में आप भी खड़े हो गए हैं क्या? इलेक्शन में
नहीं, हम खड़े नहीं. भीड़ रहेगा सब जगह. सब
मंडे को है इलेक्शन. कब है?
थर्सडे को है.
अभी से कहाँ भीड़?
अब ये हम लोग तंग है, इतना तंग करता है.